Good evening, everyone. At the outset, welcome you all to our today's webinar on SBO. I also thank at the outset our expert speaker for the day, none other than our own very senior and very close to the institute and always helping institute in all endeavors wherever Savitri ma'am is. Thank you, Savitri ma'am, at the outset for sparing your valuable time. I know you have a very busy schedule, not because you are in office, being the chief compliance and the company secretary of Reliance Industries, which is the biggest, I would say, conglomerate organization of our country. And in fact, we all appreciate your zeal to learn, unlearn, and relearn. And that's how today also you are not in Bombay, you are not in Delhi. Today again you are attending SIRC Regional Conference on a Saturday. Monday to Friday you work. Saturday again you attend SIRC event, our own institute's event, and you have a flight to catch at 8, which takes off at 8. So you will have to end up this session. In fact, I got worried when you shared with me in the pre-panel discussion that you have to get a flight which takes off at 8, and I was wondering when will we start, how will we finish, and how will you reach the airport on time. But I'm sure you are such an expert faculty that by around 6:15 in 1.5 hours itself, this topic can be beautifully explained and covered by you. I have no doubt in that. So without wasting much time, I'll initially share in 2-3 minutes about the background of this initiative taken by the institute. All my learned friends, this series which we have started, Triple E. Earlier, this was known as Triple E series, and the idea came in 2017. Then Ranjit Bhai in 2019, Mr. Ranjit Pandey, past president, he formed this Triple E, which really clicked very well with members, which is enable, evaluate, and excel. Since we all have to excel in our professional journey, and the only way we can excel is what is written in Gurbani. I feel, Savitri ma'am, I'm sure that is the only thing I can share. Rest everything we learn from you, but I'm not sure whether you have heard this quote from Gurbani earlier or not, but let me share with you because I heard it today in the morning, which is Vidya Vichare Tipparopkare. I repeat, Vidya. So what you disseminate, Vidya Vichare Tipparopkare, which means contemplate and reflect upon knowledge, and you will become a benefactor to others automatically. And that's what we are doing here. That we'll be, and you will be the benefactor. You will be the real beneficiary, and we are being benefited because of your knowledge and wisdom. And that's how we are. Our institute, our young dynamic leader of the institute, the president of the institute, Mr. Manish Gupta, the vice president of the institute, Mr. B. Narasimhan, the veteran vice president. And under their leadership, my elder brother, Mr. Dhananjay Shukla, under his committee, he's the chairman of Corporate Laws and Governance Committee. This year, this initiative has been taken. And Savitri ma'am, you won't believe, this initiative of our program has become a real hit. So the members who are attending are in huge number. Minimum is, I think, 11,000. It has gone up to 16, 18,000 also. Probably because is one reasons I personally feel is because this is the webinar. Anybody and everybody can join from anywhere. There's it's done for a limited period. The expert faculties like you who have come are the real craze for these programs and this master knowledge series, as our dynamic president has named it. And that's why I say this is one of the most amazing and hit programs of our institute. The topic today is SBO. And in fact, when Deepa ma'am asked me that Dhananjay ji has asked you, NPSG, if you can moderate, I said yes. This is a G20 work from home going on. I'll be at home. Certainly, I'll learn something because this is not my subject. I do more of litigation, arbitration, NCLT, NCLAT these days. SBO, certainly I'll learn. And I said that what I know of SBO, and I'm sure many of the participants who have not dealt with SBO would be knowing and would be agreeing with what I'll say. That actually the concept under Old Companies Act, which we had studied and which we had implemented, was registered owner and beneficial owner. Honestly, that's what I knew of the ownership concept, beneficial ownership concept before SBO came into being. And the registered owner, as we know under section 187C, was always that if you have some other beneficial owner, then you will have to do the compliances under 187C, Form 123, you will have to file. And under the Companies Act also, when it started, the new forms came in. But then the concept of SBO became a reality because of the recommendation and because of the discussions. And in fact, I would say, because India being one of the countries which is a member country of FATF, which is Financial Action Task Force. And in FATF, what was discussed and decided that each member country of FATF will have to give the details of the three things, which is very important. BOC, which is the beneficial owner, the ownership details, and the control. Who are the real controlling owners and controlling stake behind one entity? Because whenever there is an entity, like example, company A is being held by company B, is being held by company C, is being held by company D, and then above company D, there will be some individual. So the check is that ultimately we will have to go up to the ladder and ultimately find who is the individual. So what's the most important point which FATF drives is that we'll have to reach up and go up to the ladder to reach up to the individual. And, I would in fact later on request Savitri ma'am also to explain this concept of linking up to the individual, because the difference between 89 and 90, if you read, only two sections are required to be read as of now, two, which is 89 and 90, read with the rules. The rules have come. Now, this is relevant, my dear friends, for all companies. So this is not for listed companies. This is not for public limited companies. This is not for private. This is for all companies, even for small companies as I read it. And, considering the relevance of it, I think there are few questions which are yet unanswered. There are few ambiguities which are yet not clear. The ministry in fact, from the time these SBO rules have come into picture, and from the time these SBO rules have were enacted by the MCA, it has actually become a vexed issue, personally, if you ask me. Because I read about it 30 minutes back. Honestly, I didn't got much time to read it. I was thinking I'll read through each line of rules. There's some renovation going on at home and I couldn't read. But I'm sure Savitri ma'am will deal with it broadly in her opening remarks for 30 minutes. And then ma'am is more keen to take up the questions. So in the beginning itself, I would request you, if you have any questions, please send it to us on chat box or to our email IDs, and then we'll take up all the questions directly, because Savitri ma'am is more keen to answer the questions than to take a theoretical session. So there are many questions. In fact, when in 30 minutes, I have 5 questions to ask. I'm sure the members who have joined will have many more questions to ask our expert faculty. And the organization in which ma'am is working, I'm sure SBI makes a lot of sense and makes a lot of relevance, because there are so many entities which ma'am is handling. And ultimately, this concept of SBO, when I read, the act says 25%. And Deepa ma'am sent me a note which mentioned 10%. And I have already given that disclaimer that I had not read the rules. So I called her back. I said, ma'am, आपने note को शायद पुराना भेज दिया. You are saying it is 10%. The act says 25%. So madam said, yes sir, वो rules में है. मैंने कहा अच्छा दिखाओ rules खोलो. But by that time, the time was short. But then ma'am asked me, okay ma'am, what's in Deepa ma'am? Deepa Khatri ma'am is the ma'am who is company secretary and working in the institute, taking care of these initiatives working in the department. And she's the one who is the interface of institute and the ministry also, and oftenly found in ministry. And ma'am said that, sir, we have given earlier representations to institute, representation on behalf of institute to ministry also and SPO, which I'll deal a bit later. But there is one thing which has to be clear. So I asked Deepa ma'am, as per you, what is this? Because as far as before SBO, what I knew of this beneficial owner concept is registered owner, beneficial owner. One is registered owner whose name is there in the register of members. Second is beneficial owner, who may be behind the person who is the registered owner, for which the forms will have to be required, the compliance will have to be done. But then now the concept which has become a reality is finding who is the ultimate beneficial owners, UBO. And then the concept which became reality under the rules is of significant beneficial owner. Now, significant beneficial ownership means a person, individual person who is significantly holding. Now, why there is this difference in the percentage is that section 90 prescribes you the percentage is 25%. That whoever holds 25% will become significant. Whoever is holding less than 25% shareholding, the beneficial ownership in an entity, would not be called a significant beneficial owner. But the rules made this provision stricter. But the rules say that whoever holds 10%, minimum 10% or more, would become the significant beneficial owner. And then accordingly, the entire rules will apply to. Now, when Deepa ma'am said that, sir, ये वो provision है, sir, इसमें ना एक significant beneficial ownership का हमें declaration देना है. And वो तब लगेगा, sir, जब आपका ना जो beneficial owner है, वो कोई और है और registered owner कोई और है. I said, sorry, I disagree. Because my reading is of the provision of the act is that, and when you will read the rules along with it, because I remember that my colleague, my partner Lokesh gave an opinion to one of the clients, which says that when section 89 applies, 90 will not apply. Now 89 is pari materia to 187C. I am sure all members who had earlier dealt in Companies Act under section 187C, Companies Act 1956, would know that 89 is in a way pari materia to section 187C, where the concept is that you will have to give who is the beneficial owner, who is the registered owner. So the intent is to give declaration of the real beneficial owner, ultimate beneficial owner. So if 89 is applicable, in my view, 90 would not apply. Madam will have to guide us on this. Second is that how can rules make the provision stricter? I mean, the rules can make, but there is an interpretational embargo there. You know, if I read old judgments of Supreme Court, I can argue it from both sides, but I would again request Savitri ma'am to share her view on the interpretation, whether ministry could have made the provision stricter by reducing the limit from 25 to 10. And because there are qualitative and quantitative tests given in this, and there are various criteria given in the rules which one will have to follow. I would request Savitri ma'am to deal with this also, because after the FATF recommendation, after the FATF mandatory provision, because originally it was recommendation and then they said that all member countries must give the beneficial ownership of the entities which are existing in their countries, and they must give the reporting of the entire ultimate beneficial ownership. That's how the Company Law Committee in 2016, formed by the Ministry of Corporate Affairs, came out with this amendment in 2017, and the rules were brought thereafter. I think with this brief introduction about this subject, I would request Savitri ma'am to explain the provisions of 8990 and the rules, and thereafter we have already received some questions which we'll start taking up. And don't mind, ma'am, I am also one of the students. I am your student, so don't feel that the council members who come here to moderate these sessions are not learning. We are always learning from you. And I honestly, I really like all your sessions. You are one of the faculties who are always available for our profession. You are always available whenever we need you, in whichever committee, in whichever role we request you. You never say no despite your busy schedule. In fact, I have also interacted with you so many times for different programs. And in fact, friends, although it is not required, but I would be failing in my duty if I don't very briefly, introduce Savitri ma'am. As I have already mentioned that Savitri ma'am needs, although no introduction, ma'am is a company secretary and chief compliance officer of Reliance Industries with more than 30 years of experience. And I don't know, what do ma'am eat? You honestly don't look that old, ma'am. And trust me, this is honest view and honest feedback. Maybe the knowledge and the wisdom keeps you younger. And otherwise also with this much experience, I generally say that age no bar, learning bar lagatar. So with members and with veterans and experts like you, with having 30 years of corporate experience in various sectors, manufacturing, outsourcing, Savitri ma'am is also editor of Ramayya, the latest edition of Ramayya. Then ma'am is also a guest faculty at IIM Kolkata for the last 10 years. Ma'am is chairperson of the governance committee of Bombay Chamber of Commerce. Ma'am is also recipient of many scholarships and many awards. Ma'am, trust me, it's my privilege, and I'm feeling that I would be greatly benefited today after your session. Over to you, Savitri ma'am. We can't give you a big round of applause. I can only fold my hand and say thanks to you, ma'am. Thank you, ma'am.
Thank you very much. Thank you, NPS. As I've always referred to him as NPS, and while he had these very, very kind words for me. I would say that NPS is one of the budding professionals. I mean, of course, he has established his position very, very well. To me, he is much younger to me, and I've heard him. I've heard him sitting in the first row with rapt attention, and I've always appreciated the viewpoint that he brings in, the perspective that you bring in, and I have always admired and appreciated it. So we both form a mutual admiration society, and I quite like the way you brought in the perspective of FATF. And actually, you're absolutely right about the genesis of this particular section. The section was introduced so as to be able to identify the real persons behind the shares. You know, who is the owner of the shares? In fact, Section 245, in fact, I would say that even under the Companies Act of 1956, with respect to investigation into ownership of shares, this particular provision was inbuilt. And it did cover the authorities' right to go into the details of ownership. I would actually be tempted to compare Section 89 with Section 187C of 1956 Act, where disclosure was required to be made, which is actually covered in Section 89 of Companies Act 2013 also. Now, where there is a distinction between the ostensible owner and the real owner, a disclosure is required to be filed. And under the new Act of 2013, we have form number NGT 456. 4, which comes from the ostensible owner, 5 from the real owner, and 6, which is filed along with 4 and 5 by the company with the Registrar of Companies. Now, does it end over there? Answer is, in Section 90, they have very beautifully woven in the point with respect to Section 89 also. There was a very interesting point, NPS, which you brought in with respect to Section 89, which 8910 defines the term beneficial interest. And that's the starting point for Section 90. In fact, I still remember when initially I used to speak on SBO, one question which often came up was, if 89 has been filed, will Section 90 at all be attracted? Or will Section 90 only be attracted if Section 89 returns have been filed? In fact, it's the other way around. If an individual is a beneficial owner, and if he or she has already filed the disclosure with respect to the beneficial ownership in the shares, which have been filed with the Registrar of Companies, going by explanation 2 to SBO rules, which I will be doing in just a bit, this will be considered as direct holding by the individual concerned, and SBO rules will not apply if the individual is the beneficial owner and the returns have already been filed. Assuming for a second, in a company, let's assume 60% of the shares are held by Mr. A individually, 10% is held by Mr. B, and another, let's say, 8% is held by a partnership firm which has filed the disclosure of interest showing that Mr. A is the person who's actually the beneficial owner. And there is another partnership firm, BC and Co., which holds, let's say, 4%. 8 plus 4 is 12%, which is more than 10%. But in both these cases, the beneficial owner, the beneficiary is very clearly shown as Mr. A. Then in that case, you will not require any SBO filings to be done. In fact, instead of referring to it as partnership firm, let me replace that with a trust. And as you know, the trustees will be holding the shares in the company and it will be in the name of the trustee. In that case also, if the beneficiary is Mr. A and Section 89 filings have all been done, then in such an event also, there will be no beneficial ownership declaration required to be filed by Mr. A in this particular case. I mentioned that in case of a trust, the shares would be held only by the trustees. That's not exactly so if the shares are allotted in dematerialized form and the trust has a demat account. As you know, there are cases where the trust can have the demat account in its own name. And if those conditions are satisfied, the trust would be holding the demat account in its own name. In such an event, if the trust holds it in its own name, the beneficial owner would be the beneficiary. And of course, you do have the provisions of SBO, where the three different types of trusts have all been clearly referred to in this. Let me now take a step back and start as to what is required to be disclosed. Once again, NPS mentioned about threshold of 25%, which is what is referred to in section 90. But just as Deepa had clarified, the rules have referred to not less than 10%. Now, not less than 10% is the threshold. If you compare this with international practices, most of the countries internationally, the threshold is 25%. That's also because hedge funds typically hold shares in companies which are listed overseas, while in India, we do have mutual funds and all that. But in India, we have chosen a lower threshold. As per the rules, it is not less than 10%. So what exactly is the requirement? Where an individual, whether he is acting alone or through one or two more persons or a trust, now even if the persons are based overseas, it doesn't matter, where this individual holds beneficial interest of not less than 10% in the shares of a company, or the right to exercise the significant influence on the company or the control on the company, then this person, this individual, will have to file a declaration with the company giving his beneficial ownership details. Now, what exactly is beneficial interest? If you refer to section 8910, beneficial interest is the interest with respect to the shares. Now, when you refer to shares, what are the interests that go with it? The right of voting, right to receive dividends, and the right, the shareholding per se will give you the right to vote or the right to receive benefits with respect to the shares, that is the dividend. Now, if the dividend or distribution more than 10%, not less than 10%, is going to be received by an individual directly or indirectly, then such an individual is required to give this disclosure. If I were to bring it down to basic brass tacks, then what are we referring to? Three types of details. One, shareholding per se. Two, voting rights. Three, distribution with respect to the shares. And of course, there is an element of significant influence or control. If any of these get attracted, then the individual is required to file his SBO declaration in Ben 1. And the company will have to file Ben 2 with the Registrar of Companies. What exactly is the trigger here? In every case where an individual holds 10% or more, is this required to be filed? No. Only if it is held indirectly, where he holds certain portion directly, certain portion indirectly, and both put together is 10 or more percentage of the total share capital of the company, or voting right, or distribution of dividend, as the case may be, then this is required to be filed. Which means if it is purely in an individual capacity, no such declaration is required to be filed. Let me repeat this once again. If, let's assume in a company, in a private company, you have 5 shareholders, each holding 20% of the capital of the company. Now, each of these 5 shareholders, Mr. A, Mr. B, Mr. C, Mr. D, Mr. E, are they required to file their SBO? Answer is no, because the person who's holding the shares is an individual, and we have details of this individual who's holding the shares. So nothing further is required to be filed. There is no compliance under section 90 required. There is no beneficial interest here. The ostensible interest and the beneficial interest have both merged. in the self-same individual. Therefore, nothing further is required to be made. Let's take the same case. I'm giving the example of a private company because I can then juggle with a smaller number of members. Let's take this case of A Private Limited, where you have Mr. A, Mr. B, Mr. C, Mr. D, each holding 20% each, and A, B, C, D, and Co., which is a partnership firm, which holds 20%. Now, A, B, C, D, and Co. cannot hold the shares because a partnership firm is not a separate legal entity, and therefore there are 4 members, Mr. A, Mr. B, Mr. C, and Mr. D. And Mr. A, Mr. B, Mr. C, Mr. D are jointly holding the shares, where this partnership firm has given the disclosure under Section 89 saying that these shares are held jointly by these 4 individuals who are the partners in the partnership firm. So in the second case, is this disclosure under Section 90 required to be filed? Answer is once again no, because there's a disclosure under Section 89. You know the individuals who are the actual owners, and this Section 89 disclosure has been filed. Nothing further is required to be done. Let's take the third case. In the third case, let's assume Mr. A, Mr. B, Mr. C hold 20% each. Mr. D also holds 20% in the company, and the balance 20% is held by a trust which holds 20%. Now, this trust is, let's say, a discretionary trust where the trustees exercise all the rights. Beneficiaries are not really known. The discretionary trust where the trustees have all the power. In this case, will the SBO provisions get attracted? Answer is yes. In this case, SBO provisions will get attracted. Now, how exactly will you determine? Let's go to the basic provisions. And in the first example, I said where it is held directly, there will be no disclosure required to be filed, because the term explanation 1 to SBO rules, rule 2H, says that where the shares are not held indirectly, then no further disclosure is required to be filed under SBO rules. Now, what does indirect mean? Now, explanation 2 says it will be said to be held directly if the shares are held directly by the individual concerned, or where the disclosure under Section 89, that is the returns with respect to MGT 4, 5, 6, as we were referring to a little while ago, have been filed. So if those have been filed, nothing further is required to be filed under the SBO rules. Now, what if I was referring to a trust holding the shares? What if the trust is holding the shares? What if a body corporate is holding the shares in the company? Then in that case, the term indirectly will get attracted. Let's say in the same example of A, B, C, D holding 20% each and a trust holding the shares of 20%, it's very easy to know that Mr. A, Mr. B, Mr. C, Mr. D, who are natural persons, human beings, are the ones who actually are exercising all the rights with respect to 20% holding. But the fifth one, that is a trust, one needs to understand as to who is the person behind the trust. And indirectly would mean, let's assume one of the trustees is Mr. A. Now, Mr. A holds 20% in his own name, and there is another 20% here. This 20% plus 20% will make it more than 10%, and therefore Mr. A will have to make a disclosure. But why would Mr. A have to make a disclosure? Because if the holding is by a trust, if the member is a trust held through the trustee, then one needs to see whether it's a discretionary trust or is a specific trust or is a revocable trust. If it's a discretionary trust, then any trustee would be treated as the significant beneficial owner. If it is a specific trust, the beneficiary would be treated as the significant beneficial owner. And if it is a revocable trust, the author or the settlor would be treated as the SBO. Right at the outset, NPS mentioned about SBO and UBO. The Income Tax Act refers to the term ultimate beneficial owner, which means ultimately who is the person who's getting the benefit. Now, this, in case of Companies Act, the term is significant beneficial owner. And in significant beneficial owner, person, natural person is who's actually calling the shots. Now, there are these conditions, or a discretionary trust or a revocable trust. Let's take the second case where A, B, C, D, 20% each. The fifth shareholder is, let us say, AB LLP. Since it is a partnership firm, AB LLP, who would be considered as the SBO with respect to this AB LLP? Now, the AB LLP, let us say, has Mr. A as a partner of this particular firm, and this partner is Mr. A. So therefore, Mr. A will have to file the SBO declaration with respect to this AB LLP. Now, when he is filing his SBO declaration, since Section 90 says directly and indirectly, he will have to cover his direct holding of 20% and this indirect holding of 20%, which is through this LLP. In case of an LLP, it would be the partner of the LLP. It could be any partner who can file the disclosure. It would be the partner of the body corporate holding majority stake in the partnership firm. Let's say, for example, you have a body corporate which is a partner in the partnership firm. Then in that case, a person, an individual who has majority stake in that body corporate will be treated as the SBO. Now, what is the meaning of the term majority stake? The term majority stake is defined in Rule 2, Sub-Rule D as in case it's a body corporate with share capital, any person who has more than 50%, that is one half of the equity share capital, or a person who has more than one half of the voting rights, or who has the right to receive more than one half of the distribution by way of dividend or distribution in any other amount from the company. In that case, that person, that individual would be said to have majority stake. So in case of a partnership, as I was mentioning, one is a partner of the partnership firm if the partner is an individual. Second is, if that partner is not an individual and you have a body corporate, then a person, a natural person who has majority stake in that body corporate. Or the third could be a natural person who has majority stake in the ultimate holding company of the body corporate, because ultimately he is the person who's going to call the shots. So if it is a partnership firm, this is the way you would determine. So we've already looked at trust, partnership firm. Let's now move on to company. Now, this is an interesting point. If it is a company, would you have filed any disclosure under Section 89 with respect to beneficial interest? Answer is no, because a company is an artificial juristic entity entitled to hold property in its own name. So therefore, in case of a company is entitled to hold shares, there will be no 89 declaration at all. There will be no declaration under Section 89. And in case the holding is by the company, once again, you will need to see as to whether there is a person who's having majority stake in the company. And the In case of an LLP also is a separate legal entity, because an LLP under the LLP Act can hold shares. So this LLP, once again, would not have filed any disclosure under Section 89. However, you would need to file the disclosure in Ben-1 form, going by the provisions of the SBO rules. Now, with respect to an HUF, of course, in an HUF, Karta is the person who would be taking all the decisions with respect to the HUF. So therefore, the Karta will be considered as the SBO in case of holding by an HUF. Actually, the holding itself would be considered in the name of the Karta only. And if the disclosures under Section 89 have been filed, once again, you would be entitled to the exemption, and you would not be required to file any disclosure under SBO rules. This is broadly with respect to how you file it. Of course, you do have two other categories with respect to pooled investments and investment manager. I would not go into that unless there are specific questions. Every company is required to maintain a register of the interest declared by the individuals when they give their disclosure with respect to significant beneficial ownership. So when you get the Ben-1 form, you're required to maintain the details. So also the details with respect to the notices issued by the company with respect to the calling of information from bodies corporate or other bodies where the holding is not directly by individuals concerned. We'll go into that, and I'll explain that provision also in a bit. The register which is maintained by the company will also have details with respect to the returns which the company would be filing, and the register would be open for inspection by any member of the company. There is a return, as I mentioned a little while ago, Ben-2 is required to be filed by the company, and it will have all the details. Now, there's an obligation on a company to find out as to who the SBO is. So if the holding is not by individuals, the company is required to send a notice and find out and ask the member concerned as to who the SBO is. When will the company be able to send out such a notice? Let's assume in the register of members, going back to the example of ABCD plus another, if you have Mr. A, Mr. B, Mr. C, Mr. D, there is no reason to send any notice to any of these four persons. If the fifth one is, let's say, AB LLP, you will necessarily need to give a notice to AB LLP to ask them as to who the significant beneficial owner is. Let's assume it is ABC Limited. The company will have to issue a notice to ABC Limited to ask as to who the SBO is. But let's assume it is a trust where the shares are held in the name of Mr. P and Mr. Q. So since P and Q are individuals, the company would have no way to know that it is not actually P and Q are only trustees. However, there is a disclosure which has been made in form MGT 4.5 to the company saying that this is a trust, they are the trustees. Then in that case, the company will be required to write to the trust and the trustees. Basically, it will be to the trustees asking as to who is the significant beneficial owner with respect to the shares held by the trust, because the company will not know as to whether it is a discretionary trust or a revocable trust or a specific trust, which the trustees will then be able to clarify. So that's with respect to trust, where you get to know from the register of members based on the disclosure filed by them. If they have not filed the MGT 4 and 5, the company will have no means to know, because it is anyway shown in the name of Mr. Q and Mr. P, and who are individuals. HUF, once again, it would be in the name of the Karta only. Company would have no way to know that it is it's in some other entity's name, because it is an individual only. So what will the company have to do? Company will have to see whether it is shown in the name of a trust or a body corporate, which means an LLP or a company, only then the company can give a notice. The company is required to give a notice in the prescribed manner, in the prescribed form, to the trust or the company, or in case there was one significant beneficial owner earlier whose details were given, then to that SBO, asking if there is any change or any details, or if he has any knowledge of any person who has now become the SBO. If no information is provided, then the rights of a shareholder with respect to these shares would actually remain suspended, will not be exercisable, dividend need not be paid, the shares would not have voting rights, and if within 1 year no appeal is filed, then these shares will actually go to IEPF. And once they go to IEPF, if within 1 year appeal is not filed, they actually get ones which would be frozen, which would not then go to any claimant at all, because it then is barred by limitation, which basically means only if they go and file a case in the court, only then will those persons be able to claim any right. Having said that, even there, they will have to prove as to why they did not give any information, and as to what they will have to explain the reasons for delay. So actually, it's a very, very specific provision requiring details to be given. Now, the company, from its side, it has a duty to give notice asking for details of SBO. The company will have to file the return once it gets the details in Form Ben 1, and the company is required to maintain a register, and which register would be open for inspection by the members concerned during normal business hours, very similar to any other inspection which the company would be giving. The SBO rules, filing of the return, is not applicable to IEPF authorities. Now, this is because if shares are in IEPF and the amount exceeds 10% one day, 10% or more, we cannot ask IEPF to give the disclosure, because going by the purpose is to find out the natural person who's behind the shares. Now, in case of IEPF, it is the government of India, and therefore there is no reason to give it. Flowing from the same one, if the shares are in the name of the central government or the state government or any local authority, then the provisions will not be applicable. They will not be required to give any disclosure. Holding reporting company. Now, holding reporting company is not required to give any Ben 1, but the reporting company will be required to file a Ben 2 form saying that it is a subsidiary of the holding reporting company. I mean, giving details of the holding reporting company. This term, holding reporting company, requires a bit of explanation. Reporting company means a company which is covered under the SBO rules. Which is covered under the SBO rules means a company which has complied with the SBO rules, which is required to comply with the SBO rules. Which basically means it is a company which is incorporated in India and to which the SBO rules apply. Now, if this holding company has subsidiaries, then this holding company is not required to file any Ben 1 form, but the subsidiary company, which is a company in India, will file a Ben 2 form saying that it is the subsidiary of this particular company, giving details, the SIN number and all that. Why is this relaxation provided? It's very simple, because ultimately the purpose is to be able to go back to the individuals concerned. In this particular case, if the holding reporting company has individuals as its members, and the holding reporting company in any case would have complied with the SBO requirements. Let's assume the holding reporting company has only individuals. The holding reporting company in our example, let's say, is a private company with 5 members, A, B, C, D, E. It would not have filed any return, but it will still be a holding reporting company. And this A Private Limited has a wholly owned subsidiary called, let's say, BC Private Limited. BC Private Limited will only have to file Form Ben2 giving details of A Private Limited. That's exactly what this provision says. A reporting company or a body corporate or an entity which is controlled by the central government, state government, or partly by central, partly by state government, or one or more state governments will also be exempted. SEBI registered investment vehicles, because anyways they are registered with SEBI. For example, a mutual fund, AIF, REIT, InvIT will not be required to file any disclosure. Investment vehicles which are regulated by RBI or by IRDAI will also not require, or a pension fund will also not require any filing to be done by them. Broadly, these are the provisions of SBO, Section 90, as well as the rules. But as they say, the devil is in the details, and which will very clearly come out in the course of question and answer session. Because if you see the rules, they are fairly simple. But and the section is also fairly simple. But I'm sure in implementation, there are several questions which one would have. I'll be happy to answer them. Over to you, NPS. Hello?
Yes, ma'am. Thank you at the outset for giving so many practical examples. I was wondering whether anything would be left, whether any questions would be left, which members would ask. But, to my surprise, members have already sent us around 30 to 40 questions.
Oh, wow.
Around 30 to 40 questions at least. And we'll have to cherry pick few questions because we'll not be able to cover all the questions considering the schedule which you have. And so I'll start with the questions, and then if you would like to elaborate more. And in fact, Savitri ma'am, I think few questions you have already answered, because I'm looking at the questions and then I'm realizing, but still I'll ask because the member feels happy and member feels more satisfied when the question is asked and then the answer comes. So that way I'll ask those questions. To begin with, ma'am, now if the SBO of the reporting company, there are few questions which are interesting. So I'll start with the way the questions have been received by me, and then we'll add the more interesting element into it whenever we are required. So if the SBO of the reporting company dies, and if the company registers any person as temporary arrangement as nominee of the state of SBO, does company need to report this change to ROC?
Okay, so let's say the SBO of the reporting company has died, which basically means let's take a case of a partnership firm where the partner who was shown as the SBO has passed away. Now, by virtue of the partner passing away, what has happened to the rights? Let's assume the company were to have the AGM on the next day. Who would have exercised the rights? Is there someone else who would be entitled to exercise the right? In what capacity is the person saying that he has the right? Is it because he is a partner? Let's say, for example, in case of a partnership firm, one partner passes away, but there are other partners. Maybe you have given the disclosure giving details of one partner. Here it is another partner whose name then will need to be replaced. So what will need to be seen is what exactly has happened by the SBO passing away. If it is a let's say a discretionary trust, you have given the name of a trustee. What happens? What about the other trustees? Was he the only sole trustee who was managing it? In that case, what has happened to the entire thing? So change will also need to be intimated, but death would also mean that somebody else would be stepping in. If what you need to do is you need to see if there was a meeting of the company the next day, who would have exercised the powers, and then determine as to who should be coming in there. Let's say, for example, if it was a company and majority stake, nobody has majority stake because this person who's passed away, let's say he had five sons, and all five are going to get equal shares, and therefore there is no one who can claim to have majority stake in the company. Then in that case, you don't have any SBO in that particular company. That's it. So one needs to see and bring it down to the brass tacks.
Perfect, ma'am. You've explained it very nicely. Mr. A and B acting together through AB Private Limited exercise significant influence in the holding company Private Limited by virtue of a shareholders agreement. Hence, Mr. A and Mr. B are the SBOs of holding company Private Limited. Now, holding company Private Limited has a subsidiary company named as Subsidiary Company Private Limited. So can it be concluded that since Mr. A and Mr. B are the SBO of holding company Private Limited, they are also deemed to be the SBO of the Subsidiary Company Private Limited?
Okay, so this is an interesting point. Both A and B are jointly controlling, so therefore they are joint SBOs because their powers are not divided. That's point number one. Point number two, yes, they are the SBOs of Holdco Private Limited. Now the question is, Subsidiary Co Private Limited, will they be considered as the SBOs? Now Subsidiary Co Private Limited, for the purpose of BEN 2, will only be giving details of Holdco Private Limited. And it is only in the context of UBO that you would be saying as to whether you would be seeing as to whether subsidiary AB will be considered as the SBOs, because SB Private, the subsidiary company Private Limited, will only be giving details of the Holdco. Having said that, if the subsidiary company is a wholly owned subsidiary, then there is no one other than the Holdco who's holding more than 10%. So nothing further is required. Therefore, it's only UBO where you would say that A and B are the ultimate beneficial owners jointly, but there is no SBO requirement with respect to the subsidiary company.
Right, ma'am. Mr. A and Mr. B not acting together. So they are not acting together, ma'am. Are the only partners of LLPs. Now, LLP holds 5% shares in reporting company and Mr. A holds 8% shares directly in the reporting company.
Right.
I'll repeat again, ma'am. Mr. A and Mr. B not acting together and they are the only partners of LLP. LLP holds 5% shares in the reporting entity and Mr. A holds 8% shares directly in the reporting entity.
Right.
Now, the question is, will Mr. B also be considered as SBO along with Mr. A due to the combined shareholding of the LLP and Mr. A in the reporting entity?
Now, A and B are holding the partnership interest in the LLP. Now, A and A is holding 5% in the reporting company.
8%. 8%. Probably to meet that percentage, 8%. 8% and LLP holds 5%.
Okay. So in this case, A will have to do the filing as the SBO because A is a partner and here directly and indirectly, both together, he will end up holding 13%. Now here, this is what is interesting. It will not be proportionate share of 5%. It will not become 2.5%, but it will be one where you will need to consider it as 8 plus 5. It's not 10.5, but 13% here. I mean, instead of 10.5, let me look at it this way. Let's say if the partnership firm were to hold 3%, then it will not become 9.5, which is below the threshold, but it will be 8 plus 3. The whole percentage of 3 will get assigned to the name of A, although A may not be the person who's economically interested to the extent of full 3%. Will B be brought in is the question. Answer is no, because B, even if I were to bring in B's interest, it's only to the extent of 3% or, in the original example, 5%, which is less than 10%. But A is a partner and therefore it will be considered as 8 plus 5, which is more than 10%.
I'm not, because there will be some follow-up questions also, because these questions being practical, the person who is asking questions to us one person has said that ma'am has answered, and I'll have a follow-up question out of that question. So if it comes, we'll ask you later. Because there may be difference of opinion. That's what we like the most.
Absolutely. Yes, of course.
Ma'am, when a reporting company receives Ben 1, does it require to verify the facts before filing Ben 2 to ROC?
So, verifying the facts is something which you always do from a practical perspective. I would say, yes, you must. Because while the details given which are not known to the company are ones which you would rely on the disclosure made by the person concerned, but otherwise, it is something which, if you know the facts, you would definitely want it to be verified. But you're not going to be auditing it. You're just going to be generally seeing from your records as to whatever is stated is correct or not. Let's say, for example, if it is said that individually he holds 9%, and as per the company's records, it is only 3%. You would actually make that correction, and you would ask the person also as to how he has said it is 8%.
Right. Ma'am, section 90.
Person who has 10% stake in the company is always known to the company. He can't just suddenly be somebody who's, let's say, for example, there are two categories of companies. Either you're listed or you're unlisted. If you're listed, you would know every shareholder. You may not know them personally, but you would know the details of every shareholder who holds more than 1%. And if it is an unlisted company, you better know everybody.
Perfect, ma'am. So, ma'am, whether the form Ben 2 is required to be filed in case of increase in the shareholding of SBO due to dilution of paid-up share capital due to buyback?
Not required. See, what is required is who is the significant beneficial owner with respect to the shares. It is not with respect to every share that you're getting. So it is more like linking it to the particular demat account number or the folio number. It is not linked to the distinctive number of the shares.
Right, ma'am. Ma'am, the subsection 4A, capital 4A of 90, now mandates that the company shall investigate into significant beneficial owners of the company and make sure that they comply with the provision. Now, how can both companies and professionals assisting them handhold them in the entire process? So they are talking about the role of a professional and particularly the company involved.
Right. So this is what I covered very briefly when I said that the company secretary, the company, as well as the professionals assisting the company should take a look at the register of members. And the way to take it forward would be look at the register of members, look at the AGM minutes, look at the authorities that the company would have received for attendance at the meetings, not just AGM, it could be AGM, general meeting, postal ballot, all this, to see as to what kind of authority letters you have received. Because as per section 113 of the Companies Act, if a person has to cast a vote, exercise any rights as a member, you need a board resolution. So let's assume for a second, in a closely held company with, let's say, 50 members, there are 5 bodies corporate. All 5 bodies corporate have granted the authority in favor of Mr. A, and Mr. A for the last 5 years has been exercising the rights with respect to this body corporate. One would then have a reasonable belief that Mr. A is the person who's exercising the right. Let me give you another example. Let's say Mr. A has been authorized, but the board resolution very clearly states as to how he would vote, which means he's merely exercising the right to vote, but he is not exercising the decision as to how to vote. In which case, would you consider him as an SBO? Is a question mark. But at the same time, you can ask him, which is the reason when the company does this, they will ask this person as to who are the persons who are taking the decision. Please let us know the details. But he will be the first person to whom you would be sending the notice. So just to once again clarify on this, look at the register of members with respect to holdings by other than individuals. Look at the last maybe 2 years, 3 years, 5 years, of general meeting minutes to see as to attendance register at these general meetings, see the authority letters which have been given, because you're only looking at bodies corporate, or you're looking at only other than individual holding. Also ask for NGT 456, which has been filed by the company, so as to see if there is any linkage. That's the way you would then be proceeding.
Right, ma'am. You have explained this in detail, and that's what members were seeking actually. Ma'am, this you have covered, but still I'll ask so that I don't ask all the practical questions, but there are few theoretical questions which you have already answered, but very briefly you can explain again, because we have received this from 2 members. And what are the exemptions available to private limited company for filing BEN2?
So actually, it's not a private limited company, but exemptions available. So here, if there is a holding reporting company, then in that case, the holding reporting company need not give BEN1 form. Only the BEN2 form would be filed by the subsidiary concerned. Otherwise, of course, IEPF, but those are pure theoretical point, because IEPF, there's no question of sending a notice. Similarly, the central government, state government, or any entity which is controlled by the central government or by one or more state government, whether along with central government or otherwise, need not give this. Similarly, the SEBI registered entities or entities which are registered with Reserve Bank of India, like for example, REIT, InvIT, PFRDA, or with respect to the mutual funds, alternate investment funds, these are not required to file BEN1 form.
Right, ma'am. Now one practical question which we have received just now. A private limited, ma'am, is a 100% subsidiary of B Limited. B Limited is 100% subsidiary of C Limited. Okay. And in turn, A private limited is a 100% subsidiary of C Limited.
Correct.
And in C Limited, one of the promoter is holding 46% in his individual capacity.
Okay.
Please advise whether any of the company is required to comply with SBO.
Okay. So let's look at what A would be filed. A will be required to file BEN2. I take it that A, B, C are all incorporated in India. Okay. B will also be required to file only BEN2. There will be no BEN1 to be filed in A, no BEN1 to be filed in B. Now, in C, we have 46% by the promoter in his individual capacity. What about the remaining 54%? How is the holding of the remaining 54%? We'll need to see that. And based on that, we will have to who will file the form. Because individual capacity, nothing is required to be filed.
Right. Ma'am, how is partner's interest calculated? If a partner is partner in more than one partnership firm, then how has significant beneficial ownership and how it will be calculated?
So there is no requirement to divide the interest of the partner. That is, the economic interest of the partnership firm is not the determining factor for filing SBO. It says any partner. So if you have if you have a partnership firm which is holding shares, then it will be considered as indirect holding by the partner. And if it exceeds the threshold, any partner of the partnership firm can file this disclosure, and it will be considered as a disclosure properly filed. So therefore, you don't have to go to the economic interest. Let's say, for example, if a partner has, let's say, 5% share in the partnership firm with 95% with another partner, can this 5% partner file the BEN1 form if this partnership firm, along with the direct hold, is exceeding? Answer is yes. You don't have to look at it in terms of how exactly it will be done.
Right, ma'am. One question I have, because I am realizing that in so many questions I may miss my question. So let me take the due advantage, not undue advantage of moderating this. When I read the section, as I told you, I only read the section, don't go through the rules. When I read the sections, I realized that there's an opportunity there as well. Although I always say that there's so much opportunity for our members to go to NCLT, appear before AT, NCLT, arbitrations. That's how we have formed the ADR center also. But this subsection 7 is interesting, ma'am. Now, subsection 7 of 90 says that the company shall, where the person fails. Now, the option is with the company shall. Now, it's an option, or the company must, because it uses the word shall. So, it says that the company shall, where that person fails to give the company the information required by the notice within the time specified, which means the information required to be submitted to the company, or where the information given is not satisfactory. Now, the company is under an obligation to apply to the tribunal. With the tribunal means NCLT. Within a period of 15 days of the expiry of the period, for an order directing the shares in question be subject to restrictions with regard to transfer, suspension of all rights, and such other matters as may be concerned. NCLT will hear and pass an order. Now, have you seen companies going to NCLT? Because I really feel, because this SBO, ultimately UBO, although you say that it is in terms of the Income Tax Act provisions, when I realized that this is a new opportunity, but at the same time I thought, but why would any company go against their own beneficial owners? Why would they go against their own UBOs? So have you come across any such case where actually somebody has gone to NCLT? Because I haven't.
No, I haven't come across any case with respect to SBO. But I would say that, taking a cue from what you just mentioned, I actually feel there's a tremendous opportunity to be able to advise companies, for company secretaries in practice. I would say, one, advising company with respect to SBO compliance. As I mentioned a little while ago, looking at the register of members, the attendance records, authorizations received by the company, the minutes of the general meetings, and then being able to advise the company as to what needs to be done. Whether the company has issued notices, also seeing whether the MGT 4 have been filed at all or not. This itself can be one advisory. Second, at regular intervals, maybe once in 2 years, if not a year, do an audit with respect to SBO compliance. And the third is ensuring that the company sends out notices wherever required, the entire handholding of the process, and last but not the least, NCLT application wherever required. Because, if indeed there is some query, this would be the query which the company will have to then press and answer.
Perfect, ma'am. I fully agree. In fact, taking a cue from what you said, I would in fact request our secretariat to propagate SBO audit. So I'll speak to the president and the council also that why can't we have SBO audit? Because when I read the section, in fact, the question which I asked my partner Lokesh when I read this section, I said, this is a huge problem. So many times this compliance is not done. Then how are our practicing company secretaries giving, how our members are giving secretarial audit report? And when secretarial audit is given, when they say compliance of all laws, particularly company that comes into this. And I think ministry is yet at the nascent stage where the compliance of this SBO provision is yet to be checked honestly. So I think before the ministry puts a danda on our head, it is important for us to be vigilant and get proper advice and get the SBO audit done. And if there is some compliance required to be done, one must do it. Even if there is a breach of the compliance, one can get the compounding done. One can maintain the records properly, do the filings instead of tomorrow being show caused by the ministry, because ministry has yet not, to my knowledge, because there are too many questions which are yet to be answered. I personally feel there are some clarifications required to be given by ministry in this regard. And once they are able to give that, because there is so much on the platter of the ministry that this probably has been given effect to, but they are still feeling that, yes, there is too much to be done by them, particularly with regard to V3, other forms, other compliances, other regulations. So they are probably, their attention is somewhere else, but this gives us professionals. And by the way, ma'am, credit to you. Because of you, we have 17,000 members participating in this webinar today. At the moment, 17,000. So it's only because of you.
Nice to hear this. Thank you very much.
Thank you, ma'am. So I think we'll also internally debate and maybe bring out with some publication of how we can make one compliance and maybe some formatting report where a SBO audit can be done in a particular format, what should be included on the basis of the combined reading of the provisions of the Act and the rules. And then obviously we'll involve you and take your guidance. And then guide our members. This obviously gives them a new opportunity. At the same time, save the companies from a difficulty in which they'll find themselves in the times to come.
Yeah. So actually, you've raised a very valid point. And as you know, just recently, SEBI has come up with a consultation paper on FPI-related disclosures, ownership details with respect to FPIs. Also, if what you mentioned a little while ago about FATF, all this basically comes out of the same set of requirements, and therefore, in case of listed companies, this may not be so much of an issue. But unlisted companies with large number of shareholders, it will actually be one which will need to be very specifically checked. And maybe starting with even private companies. This is one area where all companies are required to comply with this. So, you would be able to see as to what kind of practices are there. Like, even if it is family-owned businesses, where there would be a lot of areas where the professionals can guide them.
Perfect, ma'am. Fully agree with you. Ma'am, now another question has come up that if
just to add, in fact, I don't know about other NCLTs, but of late I've been seeing NCLTs in the teams which are before them specifically have a question, and all the RDs have also been raising questions on SBO compliance, which is good. So, compliance will automatically be improved. Yes, please go ahead.
In fact, ma'am, since you mentioned this, even the regional director Delhi, the North also in the merger format which they sent the questionnaire, they have included this as a question now.
Right. Absolutely.
Ma'am, another question has come up that if the shareholding of SBO of a company falls below 10% or becomes nil, who is required to intimate the change to the company, that is the SBO for seller or the purchaser?
So actually, I would say that nothing is required to be done, because what you're saying is the person behind this particular holding is Mr. X. So if the holding becomes zero, so be it. Nothing further is required. The SBO has changed.
Ma'am, there is one more aspect. If 10% goes to somebody else, then the beneficial owner would change.
Correct.
But if it is split into 4 people, then it may not be relevant because it has gone below the 10%. So I think how I see it would be that if 10% has been transferred, the change is transferred to somebody else, it has gone from one block to another block, then the new block will have to be intimated.
Exactly.
Right, ma'am. So what if purchaser concludes that they do not need to disclose SBO? In that case, earlier SBO will continue to reflect as SBO in ROC records, whether there is a way out. I think they are facing this problem. That's how they are asking this question, that if the purchaser concludes that no, we don't need to disclose this to the SBO, whether there is a non-compliance on the part of the company and the company is written.
So if the, how does the company know that the old SBO is no longer the SBO?
Good question. Correct. They would be knowing, that's how they would be aware of the the ultimate owner, only then they'll get to know. Otherwise, how will they know? Because there is no transfer form being filed before the company that under 5650 you approve the transfer. No, that's not the case. It's the ultimate holding.
In that case, let's say, for example, how would the company come to know? One is, of course, it may have knowledge. Second is the old SBO may have written, in which case the old SBO then gives the details and the company issues a notice saying that we've been given to understand, please submit this. This is the compliance required to be done by you. And once again, the same section 90, subsection 7 will be the journey.
Yes, absolutely, ma'am. Ma'am, one question which you have dealt with the example, from that example, the member has taken up and made a question. If a partnership firm is a member of a reporting company, partnership, and there are 5 partners in which 4 are individuals and 1 is a company. Each one holds 20% in LLP.
Right.
And Mr. A is a member of company, partnership firm member, holding 30% share in a company.
Okay.
I couldn't understand this question, but since I got it, I have said it. How to report Bentu if A is also a member of a company?
Okay. So, if I understand the question right, there is a company in which you have certain individuals as members and an LLP. LLP has Mr. 1, Mr. 2, Mr. 3, Mr. 4 and ABC Limited as a member. Question is, because of this 20% which is held by the LLP, who should file the SBO form? The SBO form can be filed by Mr. 1, 2, 3 or 4. Here you will not be dividing it, and it is with respect to the SBO of the company. ABC Limited holding of 20% does not affect the holding of LLP in XYZ Limited. So XYZ Limited is the reporting company and LLP holds 20% of the reporting company. Now, who is the SBO with respect to the shares held by LLP? The explanation says any partner. It basically uses the her partner, which means it could be Mr. 1, 2, 3, 4. There is no problem at all. Don't go to ABC Limited. It has to be the natural person. Any of these 4 persons, you will not be seeing the economic interest of 1, 2, 3 or 4 in the partnership firm. Let's assume ABC Limited in the partnership firm holds 95% interest and 4 holds, let's say, 4% interest. The remaining 1% is shared by 3, out of which let us say Mr. 3 holds 0.5% and Mr. 1 holds 0.2% with Mr. 2 holding 0.3%. Can Mr. 1 file the disclosure despite holding only 0.2% of 20%? Answer is yes, because the term used is a partner. It could be any partner of the partnership firm.
Right, ma'am. Thank you for answering this. Ma'am, one question we have received is with regard to the family trust. Since you have already dealt with the aspect of trust in the beginning, but since they have asked a simple question, I'm still asking it. That there is a family trust of which, for the sole purpose, the benefits of are the family members. Is this trust, in this trust, the chairman holds more than 25% interest? I mean, they are going to 25%, but actually, what I mean is, I think they wanted to say above 10% because the threshold is 10. Now, will the chairman be the UBO for all the companies under the trust?
So the chairman is it's a family trust with beneficiaries clearly known, and the beneficiary is, let's say, the chairman. Okay, then the chairman would be the SBO with respect to this holding.
And UBO as well, because the question was on UBO.
It is under the Income Tax Act, so you would.
The definition is different. Have they used a different definition?
There is no definition of UBO under SBO rules. It's only SBO as per Rule H, and there's a reference to majority stake, which is in the context of a body corporate holding shares.
Right. No, I was asking from the income tax provisions whether they have defined it differently.
Income tax actually goes to the individual who ultimately holds, So I think over there, I'm not too sure about it, but there's a concept of economic interest also.
It is not present here.
Not present here.
Which will again lead to confusion.
Correct. So, if you were to consider this economic interest, then the LLP example where Mr. 1 was only holding 0.2%, would he be considered as the ultimate beneficial owner? Answer is logically no, but I would not really claim to have an expertise on the UBO concept with respect to income tax.
I see. Ma'am, if a trust, which is a specific trust, holds majority stake in the member of the reporting company, then all the beneficiaries shall file Ben 1 to the company, or only significant owner person needs to file Ben 1 with company?
So it says is a beneficiary in case of a specific trust, which means any one beneficiary can file.
Anyone.
Because basically, what are you trying to do? I would link it to some extent to section 149(3), where it says that at least one director should be resident in India. Why? Because you're going to hold that director responsible with respect to the company. Now, that does not mean that the other directors are not responsible, but this is one person who, for the purpose of compliance of the act, would be asked questions if there be any. That's the basic purpose here. So, it is 1 plus X is the way it will be recognized. It does not say all the beneficiaries. It says a beneficiary, a trustee, a partner.
Right, ma'am. One question on 89, ma'am. Since you dealt with 89 on my request in the beginning itself, question is simple. That do we need to file declaration under 89, under section 89, if a company is a wholly owned subsidiary of a foreign company, which is again a wholly owned subsidiary of another company, which has individual shareholding of 2 members equally?
So first and foremost, if the shareholding is by a company, 89 has no application whatsoever, because a company is entitled to hold shares and there is absolutely in its own name. So there is no requirement. The provisions of section 89 come into play only when the ostensible owner and the beneficial owner are different. Here in this case, the company is the owner, company is the ultimate owner also. So therefore, 89 has no application, 90 has an application. Because 90, you're looking for natural persons who you can say has the right with respect to the holding by the company.
Correct, ma'am. Absolutely clear. Ma'am, a company holding shares. Sorry, we didn't even give you time to have water or tea, and we are
no.
You non-stop. A company which is holding shares in its own name is not required to file any declaration. Whether a company can hold shares on behalf of... Yeah.
Under section 89.
Correct. Whether a company can hold shares on behalf of another person, company or individuals. If so, whether any declaration will have to be filed. If so, by whom?
Of course, a company can hold shares on behalf of another person. And if you're holding on behalf of another person, there is a distinction between the ostensible owner and the beneficial owner. Therefore, section 89 will come into play. For example, if you have formed a wholly owned subsidiary and you want 6 other persons to hold shares in the company. Now, you may have individuals holding shares as nominees of this main holding company. You may also have other subsidiaries of the company holding 1 share each as nominees. You will not be able to show the company, the subsidiary, as a wholly owned subsidiary unless you have filed section 89 declaration. Otherwise, 1 share will take out, it may be 99.9999, it is not 100. So in order to ensure that you're able to show it as a 100% subsidiary, you would file your NGT 456 saying that 1 share is held merely to comply with the requirements of law.
I agree, ma'am, but I see it a bit differently. Although I agree with you, how I see, ma'am, this the question which you have just answered is that in case, because I've dealt with this many times in NCLT matters, operation mismanagement. Now, many times the company is holding the entire stake, And still, there is only one. The holding company is the only, and there are the requirement of having 6 other members is not there. So there is a non-compliance with regard to there is a non-compliance with regard to the number of members, but it doesn't mean that it is not the wholly owned subsidiary. So
I agree.
So it will be continued to be the wholly owned subsidiary. There may be a non-compliance of the other provision. That's the question at least 5-7 members have asked. In fact, another question which has come up, which we have already answered, I'll mention the question and then say cut, copy, paste that. Please clarify if filing under SBO rules is required whenever a subsidiary company is formed. So what I have understood from day zero and before when I read 8990 is that whenever we make a subsidiary company, the SBO rules will not apply. Only 89 will apply, because if a wholly owned subsidiary is being incorporated, we will need more than one member. Wholly owned subsidiary means we will only have one shareholder holding the entire beneficial interest, whereas under company that we need for a public limited company 7 registered members. Just for being a registered members, we will show 6 more names as the registered owners and 1 as the beneficial owner. So there section 90 will have no application, which means SBO will not come into picture, and SBO will only come into picture when
same time the subsidiary will have to file BEN 2 because there's a holding reporting company.
Correct. So to the extent of filing BEN 2, SBO rules will apply. Otherwise, the entire process will go.
Right.
Ma'am, I think we can take up few more questions because I don't want to trespass your. You can red flag me the time.
I am watching the time because I don't want to miss the flight. But not to worry, I can take few more.
What place you are, ma'am? Where are you? Where is this conference being organized?
This is in Chennai, and the hotel is very far from the airport. So I spoke today in the afternoon over here on LODR, Regulation 30.
In a listed company, ma'am, if the shares are held by a closely held company, can the directors or shareholders be said to be beneficial owners?
So once again, it is not directors. The closely held company, which holds
shareholders.
Okay. What you need to see is who is holding majority stake in the closely held company. Let's assume it is a group which, in a listed company, if you say closely held company is holding shares, it definitely is part of promoter group. Then you need to see as to whether the promoter group, is the one which has majority stake. If yes, not only do they need to comply with section 90, they'll also need to file the details in table 5 of the SHP under regulation 31 of LODR.
Right, ma'am. Whether I'll directly ask the questions because there are still at least 20 questions which are left. I'll quickly try to wrap up the important ones. Whether the SBO rules have been made applicable to the holding of shares of companies, body corporates in case of pooled investment vehicles, investment funds such as mutual funds, AIF, REIT, infrastructure investment trust regulated under SEBI. Do you think these entities can be used for evasion and non-compliance?
So actually, where the member is a pooled investment. So actually, if the question is whether SBO rules have been made applicable to pooled investment vehicle and REITs and InvITs, when you apply for your registration of REIT, InvIT, you are required to give the details of the ownership as to which is the group which has formed the SPV and which is going to get the registration under InvIT or REIT regulations. So actually all this gets built in right at that stage, which is the reason they are exempting it from the SBO rules when the REIT or InvIT holds shares in the company. The operating company, when the REIT or InvIT would have the investment, at that juncture they don't have to file the SBO declaration, BEN 1 form.
Ma'am, in case there is change in the holding of SBO in the ultimate holding entity, would it be required to file BEN 2 due to change in the middle layer and not in the reporting entity?
So when there is a change in the SBO of the ultimate holding company, the ultimate holding company is, let's say, the company in India which actually has the change of SBO, that company will have to file revised Ben 1 and Ben 2 because the SBO has changed. But the subsidiaries will not be required to file anything because in any case, they continue to be the subsidiaries.
Right. Ma'am, is whether SPO is applicable to preference shares?
Yes. So actually, preference shares which are convertible will be treated as equity. GDRs, CCPS, CCDs will all be considered as equity for the purpose of disclosure. There's very clear clarification on this.
And what is the liability on the company if no declaration is submitted by SPO with the company? Is SPO liable under the Act, or company will be liable for not filing Ben 2 and not taking steps to identify? One part I have already covered, but you can again explain the NCLT part, but you can again explain.
Yeah. So actually, if the company has not sent notice, company will be liable. There are these specific responsibilities of the company, which the company will have to ensure that it has discharged. If the company has done all that, the company is not liable. But if the company has not done it, company would be liable. Yeah.
Right, ma'am. Few more questions have come, ma'am, just now, which is that is the company required to ask for SPO declaration every year? As shareholding at higher level may change.
No, what you need to do is you just need to check as to whether, see, if it's a closely held company or if it's an unlisted company, you would definitely know the movement. Similarly, in case of a listed company also, you would have to just see as to whether it features in the 1% holding. Now, of course, there's just one possibility where there may be, 8, 9 holdings through different companies, which may not be holding more than 1%, but all of them put together may be coming to 10%. Now, that is something which is a little rare, but having said that, that's something which could be checked. What you need to see is what's your total share capital breakdown. Apart from individuals, how many bodies corporate hold shares, and from the bodies corporate, you would then remove the FPIs, FIIs, because they're anyways going to be separately handled, and then you would be looking at the balance. If the balance itself is, let's say, less than 10%, you can reasonably presume that it is not required to have any specific compliances. Although, of course, there could be individuals with this put in together may go up to more than 10%, and there'll be a group of people, but those are slightly far-fetched.
Another question by me, taking advantage of the moderation. Ma'am, I am always inspired by your clarity, which you have again expressed. The clarity of thought, clarity, the way you answer the question, applying your mind and applying the provisions of law. Ma'am, what checks and balance and what system you have in your organization to ensure that there is no compliance in such provisions are made?
So I would not speak about my organization in particular because, whatever I'm saying is all my personal views. But as I explained a little while ago, what is required to be seen is take a look at the shareholding pattern, see as to who has been deciding with respect to the voting by those entities. Let's say, for example, there is shareholding by bodies corporate, but they've never voted. Okay. You will need to see as to what is the percentage of holding by those bodies corporate. And which is the reason I said look at the last 5 years, so that you are able to look at a trend by looking at the last 5 years. It gives you a reasonable idea.
Right, ma'am. Two more things, ma'am. There are few more questions, but I will not take up all of these questions since time is of constraint, ma'am. Ma'am, practically, how has the picture since the rolling out of these rules in terms of compliance and even penalties have you have seen, and what is your take on it?
So I would actually give an overall view with respect to compliance per se. The awareness of compliance under Companies Act 2013 has gone up considerably, which is a very positive sign for our country, because higher the compliance, larger is the role of professionals, and we also would then be able to move up the move up the position of India in the global ranking also, which is a very good thing. And I think any law takes a bit of time for every provision to be understood in the right way. And having said that, I think the level of maturity has already started setting in very well, whether be it in form of SBO rules or the CSR rules. India is the first country in the world to have introduced CSR, and I think the compliance levels are fairly high.
Absolutely, ma'am. And in fact, Ministry has already started taking action on CSR, which they are as of now kind enough with regard to SPO. But these kind of webinars, I'm sure, will increase the awareness and thus the compliance. Ma'am, one, if a trust holds majority stake in the member of reporting entity, then in that case, which option should we choose under column F of Band 1 form? That is status of significant beneficial owner in the member of the reporting entity. Choose any one individual in case of company or body corporate, partner in case of partnership firm or LLP. So that's the question, I think. Yes, although this is a bit incomplete. Yes, ma'am.
Yeah. See, this is a complex question. And if the trust holds majority stake, you would have to go one up and see as to who actually is controlling it. Okay, because trust holding majority stake is not clearly provided in the majority stake provision, because it's only in the context of body corporate, and trust is not a body corporate. So if it is a trust is not holding. The trust is a shareholder in the body corporate, which is the reason you're saying trust is a majority shareholder in the body corporate. This will require little more analysis to go to the ultimate significant beneficial owner.
Right, ma'am. I think, ma'am, we have covered all the questions. In any case, if there are more questions which comes up, you're always available for us. Two takeaways which I personally, one, this entire concept I could learn because of you, for which I again thank my elder brother, Mr. Dhananjay Shukla, also to give me this opportunity. Second, thanks to the members who have joined us in large number, 17,000 I mentioned. As of now, there are 17,006 members at the moment. So they need to be given applause that on a Saturday evening, despite G20 vacation going on. For other professionals like us, our office, we have kept work from home, but otherwise everybody is at home or gone out for vacation. But still, there are people like these 17,000 members who feel that they need to learn this. And special thanks to you, ma'am, that you took out time and you agreed, despite being there in Chennai, from Bombay, flying to Chennai, permitting us to do this program at Delhi, spreading the knowledge to the entire country. And I think this concept of SPO audit, which you point, I'll certainly take this back to council and in line with the provisions of SEBI, because SEBI is making many changes, and fortunately, our institute and our members are the most trusted one when it comes to compliances by the listed companies, ma'am. I'm sure your knowledge which you have spread today will go a long way in making the country as a more compliant regime, particularly SBO framework. Thank you, ma'am. Thank you, Deepa, ma'am, for getting this coordinated. Thank you, all the members. Ma'am, that's all what we can say today. We can't present any memento to you being this virtual session. Have a great flight. Do take rest and take tomorrow off, and enjoy your weekend.
Thank you very much. Thank you for accommodating this 15 minutes early completion, and thank you very much. I'm going to thank you. Thanks to all the participants. Thank you.
Thank you.
Thank you.
Thank you. Thank you.